Rob Pullen is chair of the Australian Society of Authors, whose organisation has made a submission to that fairness hearing. He joins me in the breakfast studio this morning. And from Melbourne, we're also joined by Louise Adler, the chief executive of Melbourne University Press. Rob, Louise, good morning.
Morning.
Good morning.
Rob, let's start with you. What is Google proposing, and how is it proposing to put every book online?
Well, it's proposing a step forward for international research, in as much as before this agreement, if I wanted access as a non-fiction researcher, which was held in the Michigan University Library, I would have to fly to Michigan to access it. And I will be able, under this Google agreement, to access it via the state library or perhaps my own computer.
So this is a good thing?
It's a good thing. It is a practical step forward for researchers of fiction and non-fiction. It is, however, imperfect. And one of the problems that Australian authors have with this agreement, which covers only US books,
at the moment,
US books governed by US copyright law, is that the US model will become a precedent for the Google Australia, the Google Europe, the other Google agreements, which will constitute the world's first intellectual property monopoly.
Okay, then let me ask you, and then I'll ask Louise this. How do you think this will impact Australian authors and publishers?
Well, one of the difficulties is that nobody, including Google, knows precisely how it's going to work. A difficulty which arises before that is understanding the document itself. Now, the document begins with 17 pages of definitions, including the word person. Now, most of us think that we know that the word person means folk like you and me, but it doesn't in this agreement. And anybody who is not a lawyer who reads the 17 pages of definitions will come to understand that they cannot understand the agreement. Now,
okay.
For an agreement governing copyright and rights of authors and publishers, I think that falls too short.
Okay, but just before I leave you, Rob, and go to Louise, you're representing Australian authors. The people you represent think this is a good idea in the main?
We think that it is a step forward, and we proposed at the fairness hearing in New York on the 7th of October that we support it.
Okay.
It could be improved.
Louise Adler, let me bring you in. Do you think this is a good thing? A practical step forward for authors?
I'm not sure. Google had already entered into an agreement with publishers that allowed Google to digitise our titles and to add them to a searchable online database. And that was fine because it was contained, the arrangement was contained. Users were permitted only to view a snippet of each book, and then if you were interested in reading further or to actually purchase the book, you were sent through to an online bookseller if you wanted to buy the book. That was agreement that gave Google rights to digitise content and display books by contract with individual copyright owners. That's the principle that underpinned that was respect for intellectual property rights. Mm-hmm. That was the point of that program. Mm-hmm. It seemed to me, I may be reading too much into this, but the Google Print for Libraries program, which we're talking about this morning, was an attempt to get around the fact that this was all going very slowly in negotiating with every copyright holder and every publisher. It was a laborious process. But basically what they did, Google did, was go straight to the libraries and argue that they had the right to digitise entire collections of copyrighted and out-of-copyright content. So then the question is really for Australian authors and publishers, what's our view of that? 7 million books have been digitised already. What rights do you as an author have in that material, or what shared rights do you have with your publisher in that material?
And what's the answer to that question? That seems to me to be the key question.
Yeah, well, it's very problematic because the definitions that they're using, and Rob's quite right about this, are US specific, to put it mildly. they describe in print and out of print as books that are commercially available or commercially unavailable in the US. That's not how we view Australian books. They're not out of print because they're commercially unavailable. In fact, the new technology allows us to, books need never go out of print anymore. They're always stored electronically now in this new digital revolution. We've always got the capacity to run out a copy when anybody asks us. So we don't have the same definitions around what's commercially available and commercially unavailable. And most Australian writers' books aren't sold in the US, so their book's going to be deemed automatically out of print and then freely available via Google. That's the problem. And the other issue with this is that it assumes the primacy of Google's rights, commercial rights. It doesn't assume the primacy of the intellectual property rights of individual copyright holders. So you're going to have to, as an author, opt in or opt out of the system. It's the obligation and the burden is on you to say, I'm in or I'm out of it. And if you're in to the huge and wonderful gift of $60 US. That's what you'll get for opting in. And for that pleasure, you'll actually have to go to the IRS in the US and have to apply for a US tax file number. It's hardly worth the effort.
Just on that, because I'm interested in the money here that might flow. So you get a $60 check, US dollars. Okay, that doesn't sound like much to me, but perhaps it's better than nothing if your book hasn't been selling for many years. But what about future book sales then? If people want to download your book, do you get to negotiate some kind of fee for that?
There's a deal, I believe, that shares the revenue. 67% is shared between Google publishers and the author. The profit share between the author and the publisher is a matter of negotiation between them, and the rest of it is the cream on the top is all Google's.
Okay, but so 67% of any book sale you get some portion of it.
Three way, yeah.
Well, that's a good thing, isn't it? You've got the world buying your books now suddenly.
But you have no control. I mean, you've ceded all control to the rights in a book to one place. And the whole point for publishers and for their authors is that what you want to do is re-exploit the content of those titles in a variety of ways. You publish Charmaine Solomon, your first publisher in hardback. Then you put her out in a paperback edition. Then you go and you splice her up into many, many editions of soups and desserts and and main courses and whatever. That's commercialising the content, the copyright that you've been licensed by the writer Charmaine Solomon.
And that's what a publisher does now.
Correct.
And will the publisher lose control of that process because once it gets into Google, it's just all one quick fix, one quick price book printed out?
Yeah, absolutely.
So you must be terrified of this as a publisher.
Well, I think there are. One could view it. I like the deal that Google did with publishers, which respected the copyright. The rights of the author and the publisher in the work. You had a snippet. Great. I want my potential readers, the world of readers, to know what MEP's publishing. I think that's great. But beyond that, I want to control the sale. I want to control the distribution of that content.
Okay.
That's all I've got to work with, really.
Rob, let's go to you now. In terms of control, the internet often abdicating a lot of control once things are digitised and out there in the net. But will your organisation, the Society of Authors, have a role with trying to negotiate some kind of a Google agreement with this for Australian authors? Will that time come, or are we forever bound by whatever is nutted out in the court next month?
Well, one of the differences between us and our sister organisation, the Authors Guild in New York, which negotiated this deal, is the strength of the precedent which the American Google agreement establishes. The Americans, of course, argue that as a precedent it can be fixed and tampered with and improved at any time. I don't think that's the case. Just
given what we've heard from the publisher side of things, from Louise Adler, what's your view? Do you think this could be good for authors because it will sort of cut out the middleman, so to speak, or woman?
Well, the whole future of electronic publishing is, of course, unknown to all of us, including people like News Limited and the Chinese government. We don't know what the next step is, or even if the predictions which some of my Committee of Management members, Dale Spender, were suggesting that the print book is dead. Now, is that the case? But it's not part of the Google agreement.
Okay, and just very quickly from you, Rob, I've got to ask Louise about book importation rules, but very quickly, there is a deadline on this opt-in if Australian authors?
The opt-in, look, it's today, I think. If you opt out, you're in this position. You have to negotiate your own separate agreement for your titles with Google, and you have to be prepared to bear the cost of litigation. It's not a good idea.